Your case is, remind me again, First
Citizens versus DNA Holdings and James Dean. Mr. Dean is on.
Awesome, thank you. So we're here for First Citizens Bank and Trust v. DNA Holdings LLC 15644, and we're here for.
This is plaintiff's motion to strike jury demand.
Got it. Okay, and that was filed on January 3rd, and I think there was an answer filed January 4th. So go ahead.
Thank you, Your Honor. The parties entered into an equipment finance agreement and agreed contractually in that agreement to waive all rights to a jury trial. The waiver itself was in bold print and also in caps in paragraph 8 of the law provision. Under Florida law, long-standing Florida law, parties are bound by a contract in which they sign, and that jury contractual waivers for jury trial are enforceable in Florida and in also New York. That's the Credit Alliance case that's in my motion. Additionally, the Palomares case, which is cited in my motion, says that there is no public policy reason why a contract provision waiving a trial by jury in an action arising under contract should not be enforced in Florida. A case that I hadn't cited, Your Honor, but it's Gelco Corp versus Campanelle Motor Service, which is at 677 Southern 2nd 952. It's I think it's another third district DCA case. Says that a trial court commits error when it chooses to ignore the parties' contractual waiver of jury trial and orders a common law jury trial unless there is a showing why the waiver should not be enforced. Mr. Dean has filed a response. I don't believe his response has sets forth grounds to ignore the jury waiver in the contract that he signed, and therefore, Your Honor, we believe that the motion to strike jury waiver should be enforced and our motion granted.
Okay, thank you. Mr. Dean, what's your position?
We met last week in this court.
Mr. Dean, if you want to turn on your microphone, please.
There we go. My apologies. Last time we met, this court unilaterally scheduled a CMC and added this motion the day before the hearing, and then heard this motion and failed to perform any of the duties of the CMC, as if there was no CMC at all, and hastily ruled despite my objections to the lack of time to respond. You only notified me the day before the hearing. But still, nothing changed from last hearing, which is that this court may not hear this hearing until jurisdiction is gained, and I have to today still lack service. You can't have a lawsuit without process of service, and I've written a motion for clarification, so this court will rule on that first. Because this court has not ruled on that, all you're hearing is one-sided story, which is also unfair to me. And that's part of the reason why I filed a motion to disqualify you last week, which you also did not rule on that, which you were supposed to rule on that before you scheduled this hearing, but instead you went ahead, forged ahead with this hearing, and then of course denied my motion to disqualify you because it would have been pretty silly to recuse yourself after you went through all that trouble of writing those orders. Still, the motion for clarification was the proper first step, and now, unfortunately, disqualification is the only thing that matters. And with a new judge, we'll get clarification. In addition, this court purposefully made misrepresentations at the hearing and in your orders after the hearing. That inequitable conduct is not a fair and impartial trial, which I am due by way of my constitutionally protected rights. And there's been several other due process violations I can name, but we don't have time for that. But in short, you are at this point acting under color of law and proceeding with these proceedings, and I will be bringing a federal claim, a federal action under 42 USC section 1983. The only thing prudent at this time is for you to go ahead and recuse yourself. And I want it to be clear on the record that I am a 100% service disabled United States Marine. I'm a combat veteran of the Iraq War. I'm a recipient of the Presidential Unit Citation for extraordinary courage under constant and heavy fire from an armed enemy. I was in 33 consecutive days and nights of combat. That is a United States Marine Corps record, and I deserve better than this, and I will have better than this. Thank you.
Okay. All right, but first and most importantly, thank you very much for your service. I'm going to go ahead and take everything under advisement. If you all would like to submit proposed orders by email to the division before the end of business tomorrow, you're each welcome to do that. Mr. Dean, if you would like to submit more case law supporting your position that there's grounds to ignore the waiver that's in the contract, I would welcome that additional law. Obviously, you need to copy of the opposing counsel. And Mr. Zweibel, I would give you, if you want to submit that, I would say by end of business today. And then Mr. Zweibel, I would give you until noon tomorrow if you want to counter any of that, if you feel the need to. Okay? Thank you very much, both of you, for being here. Have a good day.
Thank you, Your Honor.
Bye-bye.